4-4 is now called the State of Texas versus Shelby Nicole Celerandi. She is here with Mr. Timler, her attorney, and the state's attorney does the defendant. Formal reading of the indictment and arraignment here. We proceed in a summary.
She does, we make it.
In summary, this indictment alleges in paragraph 1 that on or about January 17th, 2025 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated. Paragraph 2 goes on to allege that you have 2 or more prior DWI convictions in 2014 out of County Court at Law number 3. You were convicted twice. And paragraphs 1 and 2 constitute the 3rd-degree felony of operating a motor vehicle in a public place while intoxicated. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. You would be fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. You must serve 10 days confinement in the county jail as a condition of probation. Do you understand what the plan is, and is this your agreement that you've reached with the state?
Yes. Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges those 2 prior DWIs in 2014, are those true and correct as they are alleged?
Yeah.
And are you pleading true and correct to this voluntarily and because it is true?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered and passed.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1, made a part of the record without objection. And anything further, I'm going to follow this agreement. I will find then that you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here, which supports your guilty plea, to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this 3rd-degree felony. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is suspended. You are placed on regular probation for 10 years. You will be fined $500. There will be terms and conditions of probation normal and customary for DWI type cases. You must serve 10 days confinement in the county jail. When can you begin that? Immediately?
Yes, sir.
And probation officer will prepare the probation order.
Let her know they may not.
There will be other conditions, including completing a DWI intervention class. That's good. You must have, as you probably heard from the previous case, an interlock device in any motor vehicle you operate.
Yes.
That you have to blow in. It has to. You have to pass the test, or else the ignition will not start the vehicle.
Yes, sir. I have one right now.
Okay, we'll follow those terms and begin your probation successfully. Okay.
Thanks, sir.
Judge, you need to see it.
Darren Patterson, cause number 24, CR 1108. Mr. Burbank is the defense attorney, is requesting recess for 4 weeks in an attempt to resolve that. And Daniel Wally.
That's the state's motion, Judge. It has something to do.
a sentence that shakes the courtroom.
To do with
Okay.
the state's radio.
Okay. And here is Chelsea Ship. Does she need to be sworn in? All right, 22-40128 is called the state of Texas versus Chelsea Ann Marie Ship.
No.
That's you with Mr. Macon, your attorney and the state's attorney. Okay. This is a very serious case. They're all serious here. Some are more serious. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 26, 2022, in Jefferson County, Texas, you committed the first-degree felony of murder with the use of a deadly weapon, namely a firearm, by shooting the complainant, the victim. Do you understand what you're charged with here? This is a first-degree felony, which means if convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range here, ma'am?
Yes, sir.
And it, so,
Is it because of the right hand check?
yeah.
It's 40 years, Judge.
Yeah. Okay, I'm gonna redo that, Jim. I know, I wish we had this pen for everybody. This pen seems to work better on the pad
Yes,
than
sir.
others.
Thank you.
And
Thank
thank
you
God.
for clarifying.
Okay. An agreement has been reached where you would be pleading guilty, sentenced to 40 years imprisonment. Is that your understanding of the agreement, ma'am? If I follow this agreement, you have no right of appeal of your case. Do you understand? You don't have. Stand up. How do you plead to this indictment, charging you with this
Her third DW, I could seal her fate.
first degree felony, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with Mr. Macon, your attorney? Are the contents here true and correct? State's Exhibit 1 is tendered into evidence.
Objection.
And without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment has been read to you. You read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer here. All of this is true. It states, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, sir.
Is there anything else to add? I'm going to make findings now. If nothing further to add by anyone, I'm going to find that Ms. Ship, you are pleading guilty to this first-degree felony of murder voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you're totally satisfied with the representation provided by your lawyer. All of this is true, it states. So help you God, out of State's Exhibit 1, and the court supports those representations with positive findings that are in the record that we state those admissions, I hereby
She pleads guilty to dodge prison time.
find you guilty beyond a reasonable doubt of this first degree felony. I am following the agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. Anything else we need to add on it? Is there any,
No, Your Honor.
nothing else from
No, sir.
anyone else?
Not today.
All right. Do you understand what has happened today, Nate?
Yes, sir.
Okay. That is all. We are in recess on this case.
Thank you, Judge.
Mr.
It is, when she gets out, I'll kind of explain the situation. Peace. This is Miss Wade again.
Let's see. We got 1, 2. She's on 3 probation.
Yes.
Correct, Your Honor.
Okay. I don't see a new indictment. These are just 3 probations where motions to revoke probation have been filed.
Correct, Your Honor.
First amended motions to revoke probation, by the way, all filed in each of these 3 cases on March 24th, 2025. Cause numbers 23 CR 2129, 24 CR 37, and 24 CR 2001 are each called the State of Texas versus Arlie Champagne Weaver. That's you.
Yes, sir.
Present with your attorney, Mr. Kimmler, and the state's attorney. Does the defendant waive formal readings of these motions to revoke probation? Can we proceed in summary?
She does with Mayor.
Raise your right hand. Do you solemnly swear or affirm any statement you make during these hearings will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Well, there's some similarity here on 23 CR 2129 and 24 CR 37. In summary, each of these first amended motions to revoke unadjudicated probation in these 2 cases similarly state that on February 5th, 2024, in this criminal district court, you were placed on 5 years deferred or
The judge makes her fate official now.
unadjudicated probation for the state jail felonies of theft in 2129 and unauthorized use of a motor vehicle in 24 CR 37. Are those allegations true and correct as they are alleged now?
Yes, sir.
There you got 8 violations. What are we proceeding on? Did y'all talk about
We
that?
have touched. I would just go through if she can have please and true and not true.
Yeah.
That's
So what?
Well, just if you would just read someone out the room, she can read up.
Okay. She hasn't entered any pleas prior to this, correct?
I believe that she had on 1, 2, and 3 because we held it in abeyance in October of 2024 to place her on the new probation in 24-2001.
Actually, there are no findings on any of these motions
That's fine.
for probation. Okay. All right, so let's take them up. New 1. States you failed to report to the Jefferson County Probation Office for the months of April, May, June, and July, but 2024. And that is similarly alleged in each of these two cases, 23 CR 2129 and 24 CR 37.
The conditions are harsher than expected.
And that was in violation of your probation order. Is that allegation true and correct in each of these cases? Are you pleading true and correct to that voluntarily and because those allegations are true as they are alleged?
Yeah.
Do you understand that a violation proven by a preponderance of the evidence or greater of one or more violations of probation, that is enough to grant the motions to revoke probation? Probation can be revoked and you can be sentenced up to the full range of punishment in each of these cases, which sure on site which are state jail felonies, not enhanced. So you're looking at, in each of these two cases, if your probation is revoked and you're sentenced, you're looking at no less than 180 days up to 2 years in the state jail. In each case, knowing that, do you insist on pleading true today?
Yes.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yep.
Stand by. Happen to these new substantive offenses, and looks like it's numbers 4 and 5.
Which
Assault, family violence, December 21st, 2024. Illegal possession of a controlled substance, February 17th of this year.
is that the Orange County?
It didn't say.
It says in Jefferson County. That is not her Orange County offense. It's a Jefferson County
Yeah,
offense.
it is Jefferson County.
The assault was refused from our office. The possession is still waiting for drug results.
Okay. And let's go number 2. This alleges in each case, this violation that you failed to provide verification of performing community service hours as required in each of these two cases. Is that allegation true? Pleading true to that voluntarily and because it is true in each case. Understanding that that also has the same consequences as what we talked about in your plea of true to allegations number 1 in each case. Let's hold all of that and go to this third one, 24 CR 2001. And again, she waives a formal reading of this motion. We can proceed in summary.
She does, Your Honor.
This one was more recently filed on March 24th of 2025. And again, this states that on October 28th of 2024, you were placed on 5 years deferred or unadjudicated probation for theft of service, a state jail felony. Is that true? And allegations 3 and 4 allege that you failed to report to the Jefferson County Probation Office for the months of November and December of 2024 and January of 2025 in violation of Condition 4 of your deferred adjudication order in this case. And allegation 4, you failed to provide verification of performing community service hours as required in that case. Or allegations 3 and 4 in this case number 24 CR 2001. True and correct as they are alleged, and are you pleading true and correct to those voluntarily and because they are true?
Yes, sir. Yes.
Find you're pleading true voluntarily and you admit that they are true as alleged. All right. Are there agreements on this?
No, Your Honor.
No?
It just took back to
Go
the
ahead.
court. She was bench warranted over here from Orange County. Judge Parkhurst in the 260th court has sentenced her to probation and ISF on new, was it That case, we can-
Burglary of habitation.
It wasn't new.
Okay, was it old?
From that
A murder charge shakes the courtroom.
all these crimes are committed.
There was an older burglary of a habitation case. And so she had these motions to revoke pending, so she was brought over here. She's 5 months pregnant, and it's my understanding, of course, I'm not an expert on these matters, at least on the female end, but that she has a high risk pregnancy. Again, I'm not an expert, but that's what it's been related to me. And in any case, whether it's a high risk or not, ISF won't take her. And so I'm going to have to give the 260th of Judge Parker. She said he's going to proceed on
How
that.
many children do you have
One.
already?
Yes,
This will be your second?
yes, sir.
How old is your other child,
Southern.
ma'am?
Southern.
So I don't think that ISF or SAP is an option if she's continued on probation. Again, my suggestion would be, I guess, to get an updated pre-sentence report so the court can be aware of what her current situation is and how she's
On
obstacles that she's had while on probation before you determine whether
On- these cases, is there any restitution?
No, Your Honor.
No, on
Not that I believe.
either.
I don't believe so.
I think that I think she would benefit from inpatient rehabilitation. I think you would agree with that, is that right?
Yes,
Have
sir.
you spoken to Franklin House or you?
Yeah. Yes, sir. I was there the day before I went to court in Orange County. And I've been in jail since then.
So you put yourself into rehab?
Yes.
I'm sorry, Your Honor. She has $250 restitution in 2129.
Are you able to pay that?
I would think her family would be willing to pay that, Your Honor. I'll represent to the court.
When?
They hear anybody? Would you be able to pay $250 restitution?
Excuse me, Your
There's
Honor.
also other situations.
There's another restitution. The cost number 2001, the amount of $3,200.43. So she has 3 cases.
I understand. Two, yeah, two, the first two were when she was placed on probation on February 5th, and the third one when she was placed on probation on October 28th
Yes.
of 2024.
The total restitution is 3,000.
Who's the 3,000? Who is that?
It's not written in that order. So I don't know. I don't have the old case with me.
Could we set it for sentencing? See what,
Now, let's see what she has in accrued time right now, and I've got a
well, I
plan.
know the court's adamant about restitution.
I know. And they're gonna, her family can pay that first restitution. What I want to do is dispose of these two
I see.
and then keep her on.
I understand. I see where you're going.
Looks like our warrants were cleared pretty quickly, though she was in other places, but our warrants weren't.
She's got 165. So you see, you hear what you see what I'm going to do.
Yes, I understand.
All right. But the restitution has to be paid, or I'm going to undo it by the end of the day.
That's the 250 or?
Yeah, the 250.
250.
Yeah. Yeah, he's going to tell you how to do it. Yes, ma'am, and we'll help you navigate through this so it can get done. Because the court has a plan here to try to whittle down these problems. Okay. All right. Anything else to add?
No.
Okay. Let's take up 23 CR 2129 and 24 CR 37. The court finds in each of these two cases that you have pleaded true in this first amended motion to revoke unadjudicated probation in each case voluntarily, knowingly, intelligently to allegations 1 and 2 of the motions, failing to report, and failing to provide
She agrees to 14 years behind bars.
verification of performing community service hours. And you have admitted that voluntarily, knowingly, intelligently, and understanding and appreciating the consequences of pleading truth to those. That is enough to grant these first amended motions to revoke unadjudicated probation by a preponderance of the evidence or greater. And the court grants these first amended motions to revoke unadjudicated probation, and your deferred or unadjudicated probation is hereby revoked by this action. In these cases, on February 5th, 2024, in each of these two cases, you pleaded guilty to theft of property, a state jail felony in 2129, and unauthorized use of a motor vehicle in 24 CR 37. You made those pleas of guilty voluntarily, knowingly, intelligently. There was sufficient evidence supporting the guilty pleas from State's Exhibit 1 admitting in each of those cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in those two cases based upon these violations of probation. And you are hereby sentenced to confinement in the state jail for 180 days. That's the minimum you can get. You will be given credit for 165 so far. So you see, you've got like 2 more weeks that you have to finish out the sentence. And restitution in the amount of, was it 200? What was the amount?
$250.
$250 is ordered to be paid in the judgment, which needs to be paid on or before the end of the day so that she can be released when she finished, as soon as she can finish these 180 days. That is in the amount of $250 to the complainant in 23 CR 2129 as her name is written in this indictment. Please get with the family members so that they get the name correct when they submit it for restitution. They send it to the probation office?
Yes, sir.
Yeah. You go to the probation office, which is not far, you go a block or so from here.
I'll explain it to you.
And there's a form a form of payment that they take, and we'll do that. We'll accept that. That resolves those two cases. On this motion to revoke unadjudicated probation in
The gavel drops, justice is delivered.
24 CR 2001, the defendant has pleaded true to allegations 3 and 4 of this motion to revoke probation voluntarily, knowingly, intelligently, and that is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. And these are allegations of failing to report to the probation as required and failing to provide verification of performing community service hours. Again, the court finds that is enough to grant this motion to revoke unadjudicated probation by a preponderance of the evidence or greater. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony, and you are hereby sentenced to confinement in this state jail for a term of 1 year. That is suspended. You were placed on regular probation for 2 years. There will be terms and conditions of probation that you need to follow so you can get released off of that early. But we're doing this because you are going to be released here on this one. You got to just serve 15 more days on the other two to satisfy those two by law. Then you'll be released, but you'll be on probation on this. And the key thing is you got to report or else you're not on probation. You have to pay the restitution back. Quicker you pay the restitution back, get you out there, get you to get an income, be responsible, fixing the messes. We all make messes. We all make mistakes. We have to fix them responsibly. That's the test for character purposes. We're helping you do your best and the best you can be. Do you understand where we are on this?
Yes, sir.
Okay. So,
Yes, no, Danielle is 2010. Yeah.
but that restitution is owed in an amount of $2,500. Did I say 2,000 or 3,000?
There's three, Your Honor.
$3,500. But that's you got to get that.
She's drowning in probation failures.
Got to get that done before the end of probation, and the quicker you get it done, the quicker. That's the key to this case. When you pay restitution back, I consider releasing you early.
Yes. Thank you.
Yes. Okay. Everybody understand where we are on this?
Yes, sir.
Okay. Any questions, ma'am?
No, sir.
All right. Good luck to you.
Thank you.
Good luck. How do you pronounce your first name?
Michael Raven.
Okay, but it's two names though, right? So Michael and Raven, but it's Ravine, not Ravine. It's Raven.
Yes.
Okay.
Yes, sir.
Peterson.
Yes, sir.
All right. You were here with your attorney, Mr. Kimler, and the state's attorney. And your probation officer. Here in 23 CR 153, we've got two things here. In 153, there is a first amended motion to revoke probation that was filed on the April 22nd of a year ago. And then we've got a new indictment in 24 CR 530 of a third-degree felony of harassment of a public servant that was filed, handed up by the grand jury on March 6th of 2024. And my guess is that first amended includes that new indictment. Maybe let's yeah. Allegation number 3 is out of these 8 allegations of wrongdoing here. Okay, so what today? Have a hearing?
Well, I'm sure the state's, she's going to plead untrue to the offense, and I'm sure Mr. Boyd would want an opportunity to prove that up.
That's correct, Your Honor.
Are you ready? Do you have your people today?
No, sir. I saw that it was set just to announce that she was found competent. I guess that's what I was looking at.
She admits to every single violation.
We'd ask the court to revisit the issue of bond on the. I know her mother is desperate to have loans. Probably been motion to production.
I have a letter from Dr. Edgar Pond dated May 22nd, 2025, where the defendant was evaluated for competency, and the evaluation resulted in his determination that the defendant is competent to proceed to a resolution of her legal issues. I'm going to call this Court's Exhibit 1. Today's date. 6/6/25. And it is made a part of the record for all purposes, and we'll keep this in a sealed form. Any objection to its?
Without objection.
All right, is it made a part of the record for this case? The defendant, motion to revoke probation began its journey on March 8th of 2024, when the defendant was alleged to have 5 violations of aggravated assault, resisting search, harassment of a public servant, all
Pregnant and desperate in court today.
on February 13th, 2024 in Jefferson County, Texas, and failing to comply with program guidelines and rules of the Moral Recognition Therapy Program, which is good. It helps people make better decisions. And then failed to pay court assessed fees and was in arrears in her required payments for probation and other fees. Then a first amended motion to revoke probation came along April 22nd of 2024 and added allegations 6, 7, and 8. It is alleged that on March 19th, 2024, which would have been about a little over a month after the first 5 allegations allegedly occurred, that she committed the offense of resisting arrest or search. March 19th of 2024 in Jefferson County, Texas, committing the offense of public intoxication on that date in Jefferson County, Texas, committing the offense of injury to a disabled person also on that date. And the defendant is on deferred or unadjudicated probation for the 3rd-degree felony of injury to a child or disabled person or elderly person, and it would be what? No, sorry about which of those. Elderly person.
Yeah, yes, that's her mother.
Okay. So, when can we have this hearing? As soon as possible.
We can have it within a week, Your Honor.
Okay.
It shall be done. All right. Huh?
Can restitution save her from prison?